for this webinar, in which Kirsty and I will be discussing some of the factors that can impact a redevelopment project. This will bring together our building surveying and business rates expertise. You'll see we've got a chat box that you can use to ask any questions or to say hello to one another. There will be a Q&A at the end where Kirsty and I will do our best to answer all your questions. So if there are any in the chat box at that time, we will address them at that point. So Kirsty and I are both chartered surveyors and both associates with Vickery Holman. Kirsty is the head of building surveying litigation, and I am the head of business rates consultancy. We're both based in our Truro office, but we do advise clients throughout the Southwest and further afield. And of course, we have teams supporting us, which do so as well. So today we have selected a case study for you, which will enable us to talk you through the various considerations relating to building surveying, neighbourly matters, and business rates liability when redeveloping a property. So as you can see, our agenda covers the pre-construction period, the period during a construction project, and the post-construction period. We will then conclude by summarising what we feel are the key considerations when undertaking a redevelopment project. Before we start, we'd just like to take a moment to remind you of the other services Vickery Holman can offer in addition to building surveying and business rates consultancy. So as you can see here, we have departments in commercial agency, property management, valuation, development services, and lease advisory. To turn briefly to our departments more specifically, as you can see here, our building surveying department can offer advice on pre-purchase surveys, the Party Wall Act, licenses, dilapidations, works specification and management, defect analysis and disputes, and lease plans, land registry plans, and boundary plans. Our business rates consultancy department can offer advice on the accuracy of business rates valuations, and we can represent ratepayers throughout the check challenge appeal process. We can also offer advice and mitigation solutions relating to empty properties and properties undergoing redevelopment works. We offer a business rates auditing service, which can uncover past billing errors, and we can also challenge and appeal council tax bans on behalf of occupiers. So today, we have selected a case study property for you. We've selected a ground floor rented office on a prime commercial street in a town centre location. The property is terraced. Planning permission has been granted for a rear extension, and internal and external renovations are planned to the property. So I'll now hand you over to Kirsty, who is going to start by talking you through the neighbourly matters which need to be considered in the pre-construction period for our case study. Kirsty.
Thank you, Jordan. So as Jordan said, for the purposes of our presentation, we're going to assume that this property is having a rear extension and various renovations. So Jordan and I can talk about various aspects of our specialities in a single neat package. You can, of course, take the distinct elements of this presentation and apply it to your projects as required. Now, first things first, we would recommend that anybody undertaking work to a property has pre-construction surveys done. These are likely to be done by various consultants at different stages in the design process, and can help ascertain the construction and condition of their own property, and that of any adjoining or nearby properties that are affected by the work. This can inform the design of the work and any method of work. They can look at ground conditions. This will have an effect on the foundation design, any temporary works that are needed, and can have a bearing on notices under the Party Wall Act. Trial pits are very useful for understanding the depth of foundations of neighbouring structures and for things like drainage design. Boundary locations are always vital to know, and ownership of boundary features to make sure that you're not working on something that you don't own. And access for vehicles and workers, parking during projects, any other bits and pieces like that, that could potentially cause a bottleneck later on in the project, should be looked at early in the process. All of these things should be done early in the design process to inform the design and allow time to liaise with relevant parties such as neighbours, but also planning and building control. We noted that this property is rented, so the tenant should check their lease to confirm whether any notices to the landlord or licenses to alter are required, and if so, what form they should take. A license to alter is an agreement by the landlord that should not be unreasonably withheld for the tenant to do alterations to the property. The tenant needs to produce relevant details such as drawings, engineering details, specifications to inform the landlord of their proposals. The landlord should satisfy themselves that the alterations will not have a detrimental effect on their property, or that they're willing to accept that risk. And depending on the wording of the lease, the tenant may have to pay associated fees for review of documentation and monitoring by the landlord's surveyor. Licenses and notices should be written and served by a solicitor to ensure compliance with the lease. And clauses within a license may include a requirement to reinstate the property at the end of the lease, or that any alterations can become the landlord's at the end of the lease.
Thanks, Kirsty. I'm just going to jump in there quickly whilst you're talking about lease considerations to say that from a business rates perspective, it's worth noting that the lease is also a consideration, as it does need to be checked before any appeals are submitted to the Valuation Office Agency, VOA, in relation to the property, in case appeals are prohibited for some reason, or in case the landlord's permission is required. In practice, however, it of course does work in the favour of all the parties to have the rateable value of the property reduced or checked for accuracy, and neither leases nor landlords tend to be prohibitive to this. Back to you.
Thank you. So the next thing to do during the pre-construction phase would be to speak with the neighbours. We always recommend speaking with the neighbours early to let them know about the work and any potential impact it could have on them. We're looking at inconvenience, disturbance, extra vehicles that might be around, any noisy works, for example. Access requirements should also be discussed at this stage, whether that's by right to neighbours' land under the Party Wall Act or as part of an access licence. And the impact on the property and any remediation work that might be required should also be discussed. So, for example, clarifying that the contractors will clear up at the end of the project and repair any damage, and any work that might be required as part of an access licence will be completed. Early consultation can help to get consent to notices under the Party Wall Act and reduce the time taken to negotiate any licenses, which can reduce the amount spent on professional fees. In terms of the Party Wall Act, I'm not going to go into a huge amount of detail now because of time restrictions, but if anyone is interested in learning a bit more about the Party Wall Act, please do get in touch. I am happy to go through in more detail and I can provide further training on this if necessary. In this case, if the tenant is going to undertake work under the Party Wall Act, they are considered the building owner under the Act, and they must serve certain notices on neighbouring property owners to gain the protections and rights under that Act. The Party Wall Act also protects adjoining owners in that case. The first thing to do is to determine what work is notifiable and to issue notices in a timely manner to avoid delays. Notices have notice periods between 1 and 2 months, and if an award has to be produced, then the timescales can be significantly increased depending on the complexity and nature of the work. The type of work that's covered under the Party Wall Act includes construction on the boundary line, work to shared walls, and excavation near neighbouring structures, and that also includes walls as well as buildings. Once the notices are served, either agreement can be made or an award, which is a legally binding document, is produced that details the timing and nature of the work. The building owner must then follow that award or risk injunction or enforcement action. We always recommend that a schedule of condition is produced of any adjoining owner's property before the work is started. In the case of damage, this schedule can then be used as a record to ascertain the amount, if any, of damage and potential causes. The Act also allows for access over neighbouring land. It is, however, restricted. It is only where it is necessary for party wall work, and work must be done from the building owner's land as far as possible. As I said, it's for party wall work only, so once the party wall specific stuff is done, then access is usually stopped unless there's a further access agreement in place. The building owner is not allowed to store anything on the adjoining owner's land, but they can place scaffolding, and all of this is subject to further notice. Other than for a couple of exceptions, the building owner usually bears the cost of compliance with the Party Wall Act. In terms of scaffold licences, there are also access and crane licences here that are relevant. These are where access has not been granted under the Party Wall Act, for example, where the work is not notifiable. There are costs associated with these licences, where unlike the Party Wall Act, we have no right of access to the neighbouring land. So the occupier in this case must consider the cost of the agreement. So this is professional fees and a payment of consideration, perhaps, for access to the neighbour's land. There's also the potential cost of any rectification of damage that's caused by the access or the scaffolding. And you should allow sufficient budget and time to negotiate this so that it doesn't impact the rest of the project. Scaffolding on a highway, including a pavement, requires a licence with the council with highways. This is different to a negotiated licence with neighbours in that it usually has a specific amount of information required and a fixed fee, and is often something I find that is sorted by the contractor rather than the developer. I mentioned here about the Access to Neighbouring Land Act 1992. It does often come up with people asking whether or not they can use that. It is restrictive in certain cases where it is for necessary preservation work only. So things like development and building an extension, for example, would not be covered under the Act. I consider it to be a little bit of a sledgehammer to crack a nut, in that it is a long and expensive process to get access through this particular Act that will involve solicitors and expert surveyors. It is better all round to speak with the neighbours and negotiate access in the first instance. So if there are any trees on the property that may have an impact on or be impacted by the work, the first thing to find out is who owns the tree. If there is a tree on neighbouring property, you do have a right to trim branches that oversail your land. However, you must offer the branches back to the tree's owner. You have no right to do anything else to that tree, to remove it, for example, or do further work. And you may still have liability for damage if that tree then suffers because of the work that you've done. And that may include things like just branch trimming, so you have to be very careful. Tree protection orders and conservation areas are also a key consideration. You should check local plans, and if you're in Cornwall, the Cornwall Council Interactive Map is an amazing resource for looking at the locations of conservation areas and the locations of tree protection orders. And if in doubt, ask an arborist. They will be able to determine whether a tree is healthy or not, the size of its root ball, any impact of the works on the tree, and what work can be done to it. So I'll pass back over to Jordan for business rates.
Thank you. So whilst in the pre-construction period, from a business rates point of view, it is possible to check the accuracy of the current business rates valuation of the premises, so before any works have begun. And this would be done in order to determine if a reduction in the rateable value can be achieved, and therefore a backdated savings period obtained, which could of course go towards funding any redevelopment works that you have planned. So in order to determine if the rateable value of a property can be appealed, we first need to inspect and measure and take photographs. Offices are valued on a price per square metre basis, so a key way of checking the rateable value of any such premises is therefore to have a professional measure the premises in full to ensure the floor area the VOA are using to calculate the rateable value is correct. Having confirmed the floor areas, we would then carry out comparable evidence research to ensure the rate per square metre used in the valuation appears fair. This involves researching comparable evidence and confirming the details of any transactions and comparable evidence, especially to analyse local relevant open market rental transactions around the valuation date for the 2023 rating list. And this valuation date is the 1st of April 2021. So it does involve looking at some slightly historic data. And of course, the further we get through this rating list, the more historic that data will become, because the valuation date for the 2023 rating list will remain the 1st of April 2021 until the 31st of March 2026. So we also look at the valuation scheme that the property has been placed in, because all properties are placed within a valuation scheme by the VOA. And this valuation scheme is intended to reflect the location, quality, and age of the property, amongst other factors. It groups similar properties together, and then a base rate is selected, or a range of base rates are selected for those properties within that valuation scheme. So we would therefore also check that the subject property had been placed in an appropriate scheme by the VOA, and that it had been correctly valued within that scheme compared to properties within the same area and of a similar age, quality, and condition. And finally, a consideration would be given to additional items which are included in the valuation of the property, such as air conditioning and external car parking. Having considered all of this, if we were to find grounds to appeal the rateable value, we would then need to be appointed as the occupier's agent on the government gateway, which would then enable us to follow the check challenge appeal process on their behalf. The check challenge appeal system was introduced on the 1st of April 2017, and this is what allows ratepayers or their representatives to advise the VOA if there should be a change to a property's rateable value. The first stage, which is what we call the check stage, is used to disclose or amend factual information about a property. So this can be the floor area or the number of parking spaces, for example. These are factual details which can and very much do affect the rateable value of a property. So if you want to later challenge the value, so if you later want to prepare an argument based on the rate per square metre of the property, you still need to first agree the correct factual details with the VOA, even if the property details are correct. So this is the stage at which you must send a check case to the VOA via the government gateway. When a check is submitted, the VOA have up to 12 months to issue a decision, and this depends on the complexity of the case and largely the caseworker workload. So it can be anywhere between about a week and 12 months, but it's average about 6 months at the moment to get a check case decision notice from the VOA. After this comes the challenge stage. So your facts on the property are agreed, and you then move on to presenting a well-evidenced argument to the VOA that the rate per square metre that they've used in the valuation of the property is incorrect based on local comparable evidence. So as I've said, preparing a challenge requires research within the same valuation scheme as the property that you're talking about. It requires a consideration of the actual lease terms of the property in question and the passing rent of the property in question, and also a detailed research and consideration of comparable evidence in the vicinity of the property, and potentially a consideration of valuation tribunal decisions for that property as well. This challenge must be submitted within 4 months of receiving a check case decision notice, and the outcome of a challenge can take up to 18 months to receive from the VOA. When a check or challenge is finalised and the rateable value has been reduced, the savings are then calculated by the local authority, and a refund will be issued for any overpayment of business rates in the interim period to the occupier. In the pre-construction period, it's also absolutely essential to consider whether or not the works that you are planning to carry out to the property will be extensive enough to have the property removed from the rating list during the period of works. If a property is undergoing significant reconfiguration or redevelopment and there is a programme of works in place, it may be possible to temporarily remove that property from the rating list and therefore remove the business rates liability. This is because whilst works are ongoing, it's likely that one of the 4 essential factors of rateable occupation can no longer be met. And this is that the property will no longer be capable of beneficial occupation. It's very important to seek professional advice about this and about the extent of the plan works and whether or not these will render beneficial occupation of the property impossible. The interpretation of case law is particularly important here. 2 of the key cases are those which you can see here on the slide. So that's New Begin v SJ and J Monk and Canary Wharf v Jackson. In the first of these, so that's New Begin v SJ and J Monk, it was held that on the relevant date, the property was not capable of being occupied as offices and was genuinely a property undergoing substantial works or reconstruction. In this case, it was deemed the property could not be occupied as it had no services and no ceiling tiles, and parts of the raised floor had been removed. So whilst the repairs would have been considered economical to carry out, and therefore the property could be considered rateable under rating legislation, the court held that this did not constitute the assumption of reasonable repair, as the property in this case was undergoing reconstruction and was not capable of beneficial occupation. In the second of these cases, Canary Wharf v Jackson, following the vacation of the previous tenants, each of the floors had been stripped back to a shell condition, although the fitting out works were not scheduled to be undertaken until after a tenant was identified. In this case, the upper tribunal held that the separation over time of the stripping out from the fitting out for the new tenant during a period of over 3 years did not prevent the premises from being under reconstruction and therefore incapable of beneficial occupation. So this case is quite important where there are gaps in schedules of works for things such as fitting out for a new tenant, because the argument could be made that the property is incapable of beneficial occupation throughout that time. So depending on the extent of the works and the timescales involved, it can be possible to delete the property from the rating list and therefore to stop paying business rates whilst the works are underway. I really would strongly recommend seeking professional advice on this during the pre-construction period to determine if your property will qualify or not. So moving on, I will hand you back to Kirsty, who is going to talk to us about neighbourly matters during the construction period itself.
Thank you. So during the construction period, we're looking at monitoring and management of the neighbourly matters. I'm not going to mention anything really about the project management or contract administration side of things. That's a separate issue. This is more just about the neighbourly side of things. The important thing in this case is to make sure that things like the programme of works is kept up to date, and to be aware that changes to scope of works may require further notices to neighbours, or the landlord may require further notices, for example, under the Party Wall Act, and that could potentially trigger further dissent and perhaps the need to produce another award. These things are all potentially very time consuming, and so as part of the pre-construction, you would want to make sure that you've done as much investigation as possible to prevent any scope changes. But as inevitably happens, something may change, but it's best to be aware that notices may well further be needed. It's also very important to ensure that you comply with any awards. You may have awards, licenses, planning requirements, building control. All of these things may well have specific things that you have to comply with. For example, with the Party Wall Award, you may have specific methods of construction that you need to follow to prevent damage to the adjoining owner's properties, or it could be temporary works that have to be put in place that are over and above what might be considered the minimum, but in order to prevent damage to the adjoining owner's properties, they have to be completed. So making sure that everybody on site is aware of these requirements and has access to things like Party Wall Awards and relevant parts of licenses so that they can comply. Scaffold licenses, for example, might also have requirements for timescales for dismantling the license, Otherwise, you could potentially be in breach of the licence and be facing penalties. In terms of scaffold and site inspections, these might be required as part of a licence. And as I said, you have to make sure that any of these requirements are complied with to prevent the risk of breach of licence. Building control, for example, might require periodic inspections and recording requirements for works that are to be covered up. And licences to alter may well require periodic inspections by the landlord's surveyor. In terms of liaison with neighbours, it's important to keep all affected parties informed of progress, any delays, any next activities that are coming up, and any noisy activities, for example. So adjoining owners, although you may have had a licence or an award put in place, it's best to keep conversation going and make sure that they're aware of what's happening. The same thing with occupants of the same building. Whilst you may not have anything directly in writing with them, they may well be affected by the work. And of course, the landlord you should keep involved as well. The type of work that you might want to inform them of might be the number of workers increasing due to a particular phase of the project. So there might be a number of considerably more vehicles around that could have an effect on parking. If there's any heavy plant to be used for excavation, for example, neighbours might want to move their cars to avoid potential damage or mud. And any noisy internal work, you probably want to inform the occupants of the same building so that they have an opportunity to work from home if necessary. Things like that, just making sure that people are kept up to date and informed, will enable them to make decisions so that they're not unduly inconvenienced. And passing back to Jordan for business rates during the construction phase.
Thank you. So, having determined during the pre-construction period that the extent of the works would be enough to render the property incapable of beneficial occupation, we would then re-inspect and photograph the property whilst the works were underway. Removing a property from the rating list during a programme of works has to be done via an application made on the Government Gateway using the check challenge appeal process, which I discussed in some detail just now. So in order to achieve this, it's necessary to draft a submission which must include evidence to support the application. The submission must include photographic dated evidence, which clearly illustrates the extent of the works that are taking place. It must also include a detailed schedule of works, details of planning consents and contractors' invoices where possible, as well as a well-written argument citing relevant case law, which proves the property to be incapable of beneficial occupation between the start and end dates of the works. It is absolutely essential that any such application is made during the works themselves, whilst the property is actually incapable of beneficial occupation. These applications cannot be made retrospectively, and if the timing is wrong, the opportunity to save money is gone. There is no leeway here with the VOA, and I have seen people miss out on these savings, having not been aware of them and having not been able to make the approach to the VOA at the required time. So back to you, Kirsty, to discuss neighbourly matters at the end of the construction period.
Thank you. So after the construction period is done, hopefully you will have spoken with all of your neighbours and everybody is still happy. The important thing now is to inspect any adjoining properties for any damage and to make sure that that is made good, dismantling scaffolding and making good any damage, and making sure generally that the neighbours are happy with what's happened. And that if there's anything that needs to be rectified, it's pretty simple at this stage. If anything's gone horribly wrong, you can rectify it at this stage, but fingers crossed it won't have done. Making sure, again, keeping up communication and checking in with the neighbours and other occupants and the landlord, making sure as well that if there are any end of project requirements under licences or licences to alter party wall awards, documentation, as-built drawings, that kind of thing, that those are produced and submitted to the relevant people. Handing back to Jordan now for post-construction for business rates.
Thank you very much. So as I've said, the check would have needed to have been submitted during the construction period. So depending how long the construction period actually lasts, you may receive a check case decision notice during the construction period, or it may be received after the construction has finished. So if the check case decision notice is received and the outcome is favourable, the property should be deleted from the rating list, and this will therefore trigger the local authority shortly after that deletion to refund you for any overpayment of rates during the construction period. If for some reason the decision is not favourable and the property remains on the rating list, we then have the option to challenge that decision, which we have had need to do in the past. As stated earlier, this must be done within 4 months of receiving a check case decision notice. But in practice, we would not have submitted a check to remove a property from the rating list in the first place if we were not satisfied that we would be successful and that the extent of the works was enough to be successful with the VOA. So if the outcome was not as expected, we would therefore proceed to challenge the decision, see it through to the end, and get that property deleted on your behalf. But all being well, the property has been removed from the rating list during the period of works between a start date and an end date. And this means that the redeveloped property will therefore need to be re-added to the rating list when the works are complete. So at this stage, we would inspect the property once again. We would draw floor plans of the new configuration and photograph the property in its new condition. We would then calculate the new floor areas, if different from the previous floor areas, and provide an estimate of the new rateable value. And to do so, we would select an appropriate base rate for the main office areas and then make the necessary adjustments for the ancillary areas, such as the kitchen, WCs, and any plant rooms. We would then submit a request to the VOA for the new property to be added to the rating list, and this would include our suggested valuation. We would also suggest an appropriate valuation scheme for the property if the redevelopment works had rendered the original valuation scheme no longer appropriate. There is no set timescale for the VOA to add a new property to the rating list. So we would make the submission and then remain in contact with the occupier and continue to check the rating list until it had been updated to include the new property. When the new assessment became live, we would check the new rateable value for accuracy, and were the new rating list entry to appear incorrect, or were we to deem the value too high, we could then repeat the check challenge appeal process once again to correct any such errors in the valuation. Back to Kirsty for a final summary on neighbourly matters during development.
Thank you, Jordan. So in summary, the main points that I would want to raise is making sure that you're prepared when it comes to projects like this, making sure that you understand what notices, licenses and agreements are required early in the planning process, and getting them sorted, written up and agreed early to prevent any delays. It's essential to get advice from professionals as early as possible. It may require several different professionals to get all the relevant advice, but it is better to spend money on fees up front and get good advice than to spend more money probably on resolving the dispute that could delay or even stop a project. Early engagement with the neighbours is essential, I would say. In my opinion, it can save time and cost when it comes to negotiating licenses and party wall awards, for example. It can help prevent disputes if people are aware of what's going on and the scope and nature of the work. And it can also allow you and your design team to get more information on neighbouring properties that you might not otherwise have been able to get hold of. That can help inform designs and protect the neighbours' properties. The important thing, I think, throughout the entire project is just to keep up communication with the neighbours, with other occupiers, with landlords, to prevent disputes and upset, and to prevent surprises. Nobody likes surprises when they're living next door to or working next door to a development project. So all in all, communication is key. Know what you must comply with and get it done early. Back to Jordan.
Thank you. Yes, so the key takeaways from my point of view are as follows. So whether a property is being redeveloped or not, it is always possible to check the rateable value for accuracy, and professional advice is definitely very valuable here. As professionals, we have the expertise to check the floor areas and to measure them according to the VOA's criteria. And we also have the expertise to analyse the valuation of the property and to find and confirm the details of relevant items of comparable evidence in support of an argument to reduce the rate per square metre. We're also extremely familiar with the workings of the government gateway and the check challenge appeal system, as we work with this every single day. And we know exactly how to write check and challenge submissions to include the information the VOA actually requires. Certain details, particularly in challenges, absolutely must be included for the VOA to consider the evidence and arguments presented. Secondly, if a check is submitted during redevelopment works, as I have emphasised previously, it is absolutely essential that this is done during the works and that a strong written argument is provided. We have seen these refused when occupiers provide incomplete or weak information in support of their application. And it's also very important to remember that retrospective applications will not be accepted. So delaying can be very costly, and conversely, submitting an application on time can generate tens of thousands of pounds in savings, even over quite a short period of time. So it's definitely something that's worth considering during reconstruction works or redevelopment works. And finally, please remember that the property does need to go back onto the rating list when the works are complete. The VOA are unlikely to inspect the new property, and it's therefore very important that the information you provide to them is as detailed and accurate as possible to ensure that you only pay what you should for the new property from the correct date. And again, professional assistance can prove to be very useful here, as there will be less likelihood that mistakes in the new rating list entry will need to be corrected further down the line, and further costs will be incurred to you. So that's it from us. I've seen a couple of questions come in during the presentation, so thank you so much. Kirsty, I think they're both for you. So Adam has asked, thank you, Adam, what would be the minimum amount of information you would expect to receive when being issued a party wall notice? So, for example, a client receives a party wall notice with no details, drawings, or specifications regarding a proposal to carry out works to a party wall and roof following a flood.
That's a very good question. It very much depends on the type of work that is being proposed. So with adjacent excavation notices, so for example, if the work involved having to redo a floor, for example, then the notices have to have a drawing that shows the depth of the excavations in relation to the neighbouring constructions, neighbouring structures and foundations. So that is an absolutely essential. If that drawing isn't there and that detail isn't provided, then that notice is potentially technically void. When it comes to work to a party wall that doesn't involve excavation, technically speaking, there may not necessarily be any attachments, as in the minimum amount of information, but the notice should include detail on what is to be done, even if it is simply in bullet point form. Most notices tend to have a drawing with them because it is much more easy to demonstrate the work that's going to be done in a drawing or a sketch, for example. So it's a little bit, it depends, which is probably not the answer you were looking for, but you need to be able to, as an adjoining owner, understand what is being done to your property or to your shared walls. If you don't understand fully, if the detail is poor, then you have the opportunity within the Act to dissent to the work. That doesn't mean that the work isn't going to get done. You can't necessarily stop it if the building owner has a right to do that work, but by dissenting, you are giving yourself the opportunity to get more information and more clarity. And dissenting means that you can then appoint either your own surveyor to act on your behalf, or you can appoint a shared agreed surveyor between the two parties, who will then get further information and put that information into an award, which clarifies exactly what is to be done, whereabouts in the building it's going to be done, and how it's going to be done. Hopefully that answers it. If you've got any specific questions, if there's a specific example you'd like me to help with, please do get in touch. Our details will be on the handouts and the emails following shortly.
Kirsty, and Adam says thank you. And then a question from Sarah was, is it just Neighbourly to keep people updated, or are there any requirements to do so?
Again, that's a very good question. I would say typically it is a neighbourly thing to do rather than a legal responsibility, perhaps. But it very much depends on wording of licenses, for example. I have seen access licenses where there was a requirement for the person getting the access to keep the licensor updated with what was going on, so that they were aware. I think it was a holiday let, so that they wanted to make sure that there wasn't going to be any undue disruption to their property. So it usually depends on wordings of leases and licenses, but I would say to help the smooth running of a project, keeping neighbours on side is usually a fairly easy win, and is usually highly recommended.
Brilliant, thank you. So if there aren't any more questions, we will leave it there. You would just see a couple of handouts have been provided during this presentation. So there's a business rates flyer, which has got a little bit more information on the business rates consultancy department, and there's a flyer relating to Vickery Holman more widely. So please do download those for your information. And as Kirsty said, we will be issuing a copy of this webinar later to all the attendees, and our contact details will go out along with those. So we are always very happy to answer any questions that you may have. So please do get in touch, and thank you again for coming along today.